YouTube, it's Tom back with another one for you. And this one is a continuation of cracking the code. This is the 10th video. And so right here, we're going to get into the truth about Esquires or lawyers, the Bar Association, Private Membership Association. And then we're going to get into, what's it called? Oh, the license to practice law. We're going to talk about what so we're going to talk about what that is. I'm talking about what a license to practice law is and where you can find it. Where you can find it. Good luck finding it. So right here, the truth about Esquires. Probably the most fundamental, foundational datum that must be confronted by today's student of law is such student has any hope of achieving ongoing success in the application of knowledge of law is that all law, and this statement includes every genre of codified law in existence, capped off by the Uniform Commercial Code, has been stealthily and artfully converted into private corporate policy, and that the administrators of this corporate policy are none other than actors within and without the insolvent, bankrupt commercial enterprise known as United States, and its creditors, the Federal Reserve, International Monetary Fund, syndicate, governments use laws, corporations use policy. This is one reason why the term public policy has replaced its predecessor, public law, in common legal parlance. So the news media and elsewhere. So it's now called public policy, not public law anymore. And I'm pretty sure you guys noticed that. And if you look at the word police, if you throw a Y on the end of that, it's policy, and it is what it is. You know what I'm saying? So you may have wondered why the term United States in the previous paragraph is not preceded by the word United States in its solecism institutionalized by constant use over a long period of time. There is nothing plural about the contemporary use of the term United States. United States is a singular proper noun, and correct usage does not include its antecedent definition article. The United States is a corporate trade name, like General Motors, and identifies a corporation, albeit federal and municipal, but a corporation nevertheless. Just as General Motors does not imply a plural number of motors, just that somehow general in nature. United States does not imply a plural number of states that is somehow united. Just as, and I mean, if you think about it, a state is just the condition of something, and states change, right? So United States could just be the different states of something that is united. It doesn't necessarily make reference to United States as we think it is, right? So just as proper English does not include the Canada, the Finland, the Egypt, and the like in common parlance, it likewise does not include the United States, and the implication of a plural number of states slightly and injuriously implants a erroneous notion in the mind of the reader's listeners, just as the state of Great Britain appears in the Declaration of Independence 1776, and the state of Israel is mentioned daily in the news media. The state of the United States is far more accurate and identifier for what is erroneously conveyed by the use of solecism, the United States. United States, the proper reciprocal of the name, identifies the for-profit bankrupt commercial enterprise incorporated on February 21st, 1871 in Washington, D.C., presently managed by the receiver and bankruptcy Secretary of the Treasury of Puerto Rico, aka Secretary of Treasury. So as you know, everybody's been commercially trafficked off of the Americas, right? And they have everybody listed as essentially lost at sea and shit like that. So that's what's going to bring maritime into the mix and all that, which you find in all the language that they use anyway. So a most insidious jurisdiction. The following legal precept, however simple, reveals the source of more personal and international grief, misery, suffering, despair, chaos, and the loss of life can presently be imagined by nearly everyone outside the inner circle, and that is payment, consideration, set the forms of law, i.e. the mode of payment in any particular transaction sets the applicable jurisdiction for resolution of any dispute, controversy arising out of any matter concerning that transaction. This unassuming little aphorism points the way for the serious student of history, politics, and economics past all the highfalutin authorities and those through the looking glass and into the sprawling spectacle spectacle of the most pervasive and all-consuming confidence game in the history of the world. It transcends all national boundaries and establishes venue for the unqualified commercial conquest of mankind, the artificial private corporate jurisdiction of the Federal Reserve notes. All courtrooms in America today are commercial marketplaces dealing in matters bearing exclusively upon the private commercial script known as Federal Reserve notes. The notion of the halls of justice is an ancient fable. Today's courtrooms are impersonal businesses under the jurisdiction of a foreign occupying military power that managed from the bench from the Italian bank or banca or bank by merchant bankers called the judges and magistrates. And you know, magistrates are magi, right? And you know what a mag is? It's a fucking magician. It's black magic. That's why they wear them black robes. So who enforce private copyrighted corporate policy known as code, wholly owned by British corporations. The business of the court consists of admitting attorneys wishing to conduct business and adjusting the balance of accounts between debtors and creditors transacting in Federal Reserve notes. Federal Reserve notes, FRNs, who come before it and consent to have disputes resolved in this, America's modern judicial forum. Esquires. Esquire, from the Middle French, esquire, shield bearer, from Lower Latin, so essentially a shield. Originally, a shield bearer or armor bearer, and attendant on a knight. In modern times, a title of dignity next in degree below knight and above gentleman. So essentially, this is a title of nobility, which I believe is not allowed in the American continent, but they go ahead and dish them out though. As can be seen above, an esquire is a title of nobility holding shield bearer for the king, queen of England, and takes the lead against any with whom the crown desires to engage in battle. Officially, all bench officers, bar members, judges, and magistrates and attorneys in America are esquires. Officers in service of the crown. In legal commercial terms, they are foreign-based merchants in commerce. CUCC 2-104, enforcing the private corporate policy of their British liege lords or employers against unruly colonial belligerents, American customers who are deceived and coerced into using their commercial script, the currency of the private, foreign-owned Federal Reserve Bank, and who is also out of ignorance and bewilderment and the instinctive urge for survival, continually attempt avoidance and sometimes even unlawful evasion of the corporate policy, Internal Revenue Code governing the privilege and benefit, albeit compelled of using such. So basically, out of ignorance, everybody is scared and in a need for to fucking survive. You kind of default to just doing whatever they say, and basically what they're just trying to get you to fucking engage in commerce and agree to their contract. So today, all crimes including murder are classified, categorized, and addressed strictly as commercial. You see that? So even murder. So if you guys know how to discharge a bill, you should be able to get off a murder charge too. So you might want to pick up them books if that's what you're trying to do. So charges by the militaristic merchants who own and operate the legal system, issue the codes, and dictate over government. This fact is officially acknowledged at Title 27 of the Code of Federal Regulations, Section 72.11. This single section of the Title 27 alone confirms the undeniable supremacy of the applicability of the UCC in all legal matters in every American courtroom, as well as others throughout the world. Because Title 27 is a penal code, and penal is a copywritten codes and statutes that these people use to prosecute what they call crimes. So, you know, ultimately, basically what this is saying is that everything is commercial in nature. Everything. So that would tell me that you should study UCC, because that's what governs commerce, right? So that is so there is no law. There is only codes and statutes. And when you learn the governing principles behind commerce in general, then you should always be fine. When you learn contract law, you win the game. Debunking the mythical license to practice law. Oh yeah, so you guys got to go look for these. I challenge you to Google a license to practice law and tell me what picture pops up. Send it to my email if you find one. If you find a picture that says license to practice law on it, because I want to see that shit. I've never seen one. So newspapers and television's media chant incessantly about the so-called license to practice law. Bar association attorneys do not possess any such license to practice law, but they can and are nevertheless accused of it in California Business and Professions Code, in what can only be hailed as a lexical ledger legerdemain, brilliance in the devious use of words of the highest order. The code encrypting esquires in government has successfully bamboozled even their own kind in convincing all the existence of the almighty license to practice law. The following analysis should thoroughly disabuse anyone in such misconception. Whereas the notion of a license to practice law, quote unquote, is scarcely mentioned in state and federal codes, the requirement and parameters surrounding every other kind of license in existence are spelled out in mind-numbing detail, e.g., vehicle code, internal revenue code. The sacred license to practice law, however, is as undefined and elusive as the wind, where it comes from, which agency of government issues it, whose signature is on the certification, how is it even conferred, where one goes so he can see one of these things and examine it. What the tenor, duration, effective period of the license is, what the cost of the license is. These are other intensely pertinent questions remaining unanswered by the codes that foist the implication of its existence upon us. Here is a front row seat for observing the word, manipulating esquires both in and out of government in action. California Businesses and Professions Code, Cal B&P, the 6000 series, of which is also known as the State Bar Act, and Section 6002 is the solitary code section in all California code that proclaims that any such licensure was ever issued, but it does not also tell us which government agency issued it, and likewise where one can go to see one of these things. Section 6125 of the same code discusses the practice of law and bar membership. 6125, necessity of active membership in state bar. No person shall practice law in California unless the person is an active member of the state bar. That just goes to show you that that's what they think a fucking license to practice law is. Okay, so 6002, members. The members of the state bar are all persons admitted and licensed to practice law in the state. So that tells you exactly what it is right there. So they think that a state bar private membership is a license to practice law too at the same time. Yeah, right. So these two cities appear innocent enough, but a glaring outpoint is that the reference entirely different jurisdictions. Clause 6125 is applicable only in California. Clause 6125 pertains only in this state. California means the original de jure California Republic as described in the 1849 California Constitution. And this state, however, per California Revenue and Taxation Code, means that the de facto federal territory under the control of the District of Columbia, aka United States, and expressly excludes the de jure California. So it's basically saying that it's only in the commercial aspect of California, which would be the all caps, and not the de jure, which is a corporation essentially. So whereas California has a sovereign constituency, flesh and blood men and women living on the land under common law, and this state signifies the federal state of California, which is subject citizen of the United States persons existing under statute in an artificial realm. There is no other plausible, coherent explanation for not using the identical term in each section. For this reason and this reason alone, Clause 6125 and 6002 bear no meaningful relation with each other. So, if that don't clarify what it all is right there, it's just a bunch of fucking games. And, so none of these, there is no such thing as a license to practice law. But, I mean, they're not going to tell you that, but I will. So, and find one. Find one if you think that there is one. You know what I'm saying? You guys got to stop fucking believing whatever the fuck these people tell you. Truth is self-evident. If it's some shit that somebody has to convince you of, it's a fucking lie. And if there's no first-hand witnesses, then it's fucking hearsay. You know what I'm saying? So, it is a game of chess. Stop playing checkers with these assholes. That's what I got for you for now. Until we meet again.